Shall I shoot him in the back when he passes?
No, I want this to be a fair fight. I'll shoot him in the back.
Fair fight?
He was killed from behind, like the others.
Well, go ahead, Bob. What are you waiting for? There's my back.
It's one thing to shoot a man. It's a whole other thing to shoot him in the back. Even actors just playing cowboys have refused roles where their character shot a man from behind. No, we prefer our confrontations face to face. This is true whether it's a gunfight at a poker table or a verbal fight at a witness chair. Bullets are not the only things that can hurt you from behind. Words can also wound.
That book was written by a bunch of stupid girls who make up rumors because they're bored with their own lame lies.
Some lies are so serious that the police may even come knocking at your door. When this happens, clearing your name is no easy task. While you're supposed to be presumed innocent in a courtroom, no one looks at the stranger on the side of the road in handcuffs and thinks, well, I wonder why that innocent boy is being arrested. While the presumption of innocence is essential, if you're fighting a false accusation, it's usually not enough. Walking away from a criminal charge will likely require confronting your accuser. Today in a criminal case, you have the right to confront your accuser. The Sixth Amendment's Confrontation Clause provides, in all criminal prosecutions, the accused shall enjoy the right to be confronted. While the language of the Confrontation Clause appears fairly straightforward, courts' interpretations of it for the last 200 plus years have been anything but. The Confrontation Clause is based upon what we call the common law. That's the body of law developed in England through decisions of courts, not legislatures or a king. At the time the Founding Fathers drafted the Confrontation Clause, in criminal cases, the common law did not permit a person to testify to what someone else said, with very few exceptions. Some of the first decisions regarding the Confrontation Clause seem to apply it consistent with its common law origins. A statement made prior to trial by an absent witness was not permitted unless there were some very specific circumstances. First, the person had to be truly unavailable, and second, there had to be a prior opportunity for cross-examination. However, as time passed, several cases seemed to move away from the Confrontation Clause's intended purpose. Then came Ohio v. Roberts. In 1980, a Supreme Court decision would change the meaning of the Confrontation Clause for almost the next quarter of a century. In Ohio v. Roberts, the Supreme Court moved further away from the intended protections of the Confrontation Clause. Roberts changed the test for admitting the statement of an absent witness. While unavailability remained, the requirement of a prior opportunity for cross-examination was stricken. In its place, the court now would use what it called the indicia of reliability test. Essentially, the court adopted the same test as used in civil cases. In civil cases, people do not have a constitutional right to confrontation. Here, the rules of evidence, not the Confrontation Clause, would determine whether jurors would receive an absent witness's statement. The rules of evidence are much more permissive when it comes to the admissibility of evidence. Unlike the Confrontation Clause, the rules of evidence contain numerous instances where the hearsay of an absent witness would be allowed at trial. The indicia of reliability test was just another way of saying the court was abandoning the constitutional protections of the Confrontation Clause in favor of the rules of evidence. The Roberts decision was a wound to Americans' right to confront their accusers that was left untreated for almost 25 years. In 2004, something unexpected happened.
There has been an awakening. Have you felt it?
To the surprise of many that believed the Confrontation Clause was beyond repair, the Supreme Court gave it new life. In Crawford v. Washington, one of the court's most conservative justices authored a decision that obliterated the holding in Roberts. In Crawford, the prosecution attempted to introduce the recorded statement of Mr. Crawford's wife, who was not available for trial. Despite Mr. Crawford's objection, the court allowed the tape recording of her prior statement to be played to the jury. After the prosecution relied heavily on the recorded statement in its arguments, Mr. Crawford was convicted. However, the U.S. Supreme Court reversed. Justice Scalia, writing for the court, pointed out what now seems obvious. Roberts got it wrong and was inconsistent with the language and the intent of the Confrontation Clause. Crawford established that an absent witness's statement should only be presented to a jury when the witness is unavailable, there's an opportunity for prior cross-examination, and the statement was not testimonial, that is, not intended to bear testimony. Crawford seemed to reset the Confrontation Clause analysis back on the correct path. However, Crawford did not end all attempts to present juries with unsworn and untested evidence of an absent witness. Thankfully, it also didn't end the Supreme Court's application of the Confrontation Clause, consistent with its intended purpose. 5 years after Crawford, in Melendez-Diaz versus Massachusetts, the prosecution was permitted to present the jury with a forensic analyst's report without the analyst having to testify. Applying the holding of Crawford, the Supreme Court reversed, determining this violated the Confrontation Clause. Similarly, 2 years after Melendez-Diaz, in Bullcoming versus New Mexico, the court held that the Confrontation Clause precluded the testimony of a toxicologist testifying to the work of a different toxicologist. Crawford, Melendez-Diaz, and Bullcoming were a promising trilogy. That is not to say the Confrontation Clause debate between our government and the people is over. New arguments and new members of the Supreme Court sometimes result in new rulings. Despite its resurgence, the Confrontation Clause debate continues. The Constitution is of our own making, and so is its application. The Confrontation Clause reflects our choice to prevent convictions where a person is unable to cross-examine their accuser. The Confrontation Clause reflects our choice to create a government unlike King George's England, where the government could use unreliable hearsay as a means of tyranny. The Confrontation Clause reflects a choice that we made a long time ago, and we're lucky that the Founding Fathers made that choice, because you never know when someone will try and shoot you in the back.